Thank you, Your Honor. Everything indicated by Ms. Cutts is correct. Mr. Berry has been advised of all of the complaints in the probation violation cases, including the original charges as well as the 2 supplements that were mentioned. I have advised him of his rights as it relates to the probation violations, and he is prepared at this time to waive any rights he has to either a probable cause or final evidentiary hearing and plead guilty on the probation violations as charged in both cases. Prepared to move forward with sentencing as well, Your Honor, and we have had an opportunity to review the pre-sentence report.
Okay. With regard to the original probation violation that is set for final hearing, the violation is that you were arrested for all the incidents that occurred on April 12th of this year. Do you understand that charge?
Yes.
And furthermore, that you had contact with Sophia Cicconetti. Do you understand that charge?
Yes.
With regard to the addendum, on April 20th, you submitted a screen which tested positive for marijuana. Do you understand that charge?
Yes.
And are you going to waive your final hearing with regard to the original violation and the addendum?
Yes.
With regard to the addendum that was filed, the violation is that you were living at 294 Stonehaven and did not report that to your probation officer. Do you understand that charge?
Yes.
And then further contact with Sophia Cicconetti. Do you understand that charge?
Yes.
And also that you had contact with the Painesville Police numerous occasions and did not report that information to the probation officer. Do you understand that charge?
Yes.
And Mr. Springer indicates you're going to waive your right to a probable cause and a final hearing on that addendum. Is that correct?
Yes.
All right. Then with regard to all of the allegations in the 3 filings, what is your plea to each of those allegations?
Guilty.
All right, I'll accept your guilty plea and find you guilty of those violations. All right, Ms. Springer, would you like to speak as to sentencing both on the 23 case and the 19 and the 20 case?
Yes, Your Honor. Thank you. Your Honor, Mr. Berry recognizes that this court is really in the best position to understand all of the intricacies of what has happened over the years in this relationship between Mr. Berry and Ms. Cicconetti. The court has heard all of the cases. The court has heard the bench trial in this case, and Mr. Berry respects the court's judgment and the ability to appropriately sentence him in these matters. I think one of the biggest regrets that Mr. Berry has is obviously his ability to continue to be a father for his child. That's the most important thing for him, and his daughter means everything to him. And as we've been sitting here, he's just been talking about her and how when he goes to prison, the impact that's going to have on her. But he knows that that's because of his actions, and he knows that he has to face the consequences, and he's prepared to do that, Your Honor. Also, it's regrettable that Mr. Berry was on probation and coming in and, things appeared to be good, although he was still living with Ms. Cicconetti and having contact with her. And the court has given him the opportunities. But Mr. Berry has severe and persistent mental health problems. He has done a lot of things that this court has given him in order to work on himself, but he needs to continue to do that, and he knows that. And he is prepared to do that.
Mr. Berry, what do you want to tell me before I impose sentence in this case?
I just want to say, life is about choices, and I feel like throughout this time, throughout my life, I've made a lot of poor decisions and poor choices. And I think as a man, I've always wanted to, have some sense of control, controlling the things around me, controlling to be able to, be a father and be a good man, or, controlling if somebody's going to do something wrong, or controlling all these things that I can't control. And I realized, like, the only thing I can control is myself, and I failed at doing that at times, you know. And I just want to say that regardless of anything wrong or right, I accept full responsibility for what I did, because I made the choices to come in here and say that everything was going fine when it wasn't. I made the choices to not report the police reports. I made all those choices. So with that being said, you know, I accept whatever you impose on me. And I also want to say I apologize to you, Sophia, you know, for everything that we've been through and everything that I put you through in the past. And, you know, I just take full responsibility for whatever transpired between us. And I know I can do better. I know I got mental health issues. I know I got things I need to work on. And I'm prepared, you know, for my future to work on those things and get better. And I just wish you the best, and I hope everything works out in your life. And I just want to do what's best for me at this point. And I know what's best for me is not being in a relationship with nobody. You know, I got a lot of things to work on. And as bad as I want to be in my daughter's life, at this moment, you know, I got to worry about me so that I can be the best person I can be for her. Because if not, then I'm going to continue to keep coming down this path, keep coming to jail, keep getting in trouble, keep doing the same thing over and over and over and over and over and over. And I'm just tired. I'm at a crossroad where it's either make or break. Like, I'm either going to get it together now and make the right choices and do the right thing, or I'm going to continue down this path. And I don't want to continue to do this because my daughter's 6 years old. Before you know it, she'll be a teenager, and I then missed out on half of her life already. And, you know, I don't know. I don't know what more to say. I just accept whatever happens to me today, and I just live with choice I made. So.
All right, Ms. Cutts?
Thank you, Your Honor. Your Honor, the state just wants to verify that you received the victim impact statement and have been able to review that.
Yes.
That was provided by Attorney Cicconetti, who is present in court today. Your Honor, these cases obviously are very concerning to the state as well as to everybody in the courtroom. I'm going to focus the factual aspects a little bit more on the sentencing case on the 2023, the one that was the bench trial. In that case, the victim suffered psychological harm. There was the menacing by stalking of the repeatedly having the defendant come up to her both in February of 2023 and April of 2023, showing up at locations she was at, to the point that she was not sleeping at home many nights. She was looking over her shoulder. On one occasion, he came into the house grabbing her wrist to try and get to her phone, showing up at places not just once, but then when knowing that he was not wanted there at that time, would return again. Police were called numerous times. He would show up at a house she was at multiple times, yelling in the early morning hours, disturbing both Ms. Cicconetti as well as other individuals as well. There's that aspect. Obviously, the history of violence that was discussed, which does include the 2019 and 2020 cases, been ongoing with physical, mental, emotional abuse, at least back to 2015, where the court has seen the pictures of injuries to the throat area as well as arms, things of that nature, visible injuries that lasted and obviously were painful and scary for Ms. Cicconetti. Obviously, the relationship with the victim facilitated the offenses. The attempted burglary and the menacing by stalking does not require that there be a relationship. Obviously, the violating protection order, there would be a relationship. But for the other counts, that was not required. Many of these offenses were committed in the vicinity of their child. The February 26th, where he came into the home and grabbed the phone, she was present for that. She was present at Cityscapes. She was also in the area for various history of violence aspects that came through that she was present. These offenses in the 2023 case were committed while the defendant was on probation in two separate cases. On the 2019 case, which is a F2 burglary, M1 assault, that case, the defendant was originally given prison. He was given the opportunity of judicial release. He had two probation violations on that case and now has a pending violation. The other case, he was on probation for the 20 CR 1323. That's an F3 domestic violence. So obviously, with those, he has a history of criminal convictions that go back to 2011. We have drug abuse, 2013, disorderly conduct, 2014, obstructing official business, 2015 is an aggravated assault, with the victim being Ms. Cicconetti, as well as another assault in 2015. In 2017, the domestic violence, trespass in a habitation, and attempted abduction. That case, he went to prison, was given judicial release, had 2 probation violations, but that case, probation has expired. He also, in 2017, had an OVI refusal. In 2019, as I stated, he had the burglary and the assault and attempted abduction, which is before the court today. In the 2020, the F3 domestic violence, which is before the court today. He has not responded favorably to previous sanctions. He's had multiple probation violations and new cases. The vast majority of these cases, the victim is Sophia Cicconetti, at least when their relationship started in 2014, 2015. There are questions about drug and alcohol issues. There was testimony, as the court heard, that many times when things occurred, the defendant had been drinking. That's true of the history of violence aspects, the priors. There were often times that he was intoxicated, as well as we have had where he has tested positive for marijuana on different occasions while on probation. So he has been to prison on 2 prior occasions, back in 2015 to 2016 on the aggravated assault, and then in 2019 to 2020 when he was granted judicial release. Obviously, I could go on with specifics of the injuries and the cases. The court was privy to all of that during the trial, was able to see the photographs of the injuries. I won't go through all of that, but I will stress to the court, just for the record, that when individuals go for the throat, leaving marks on throats, which in this case there are multiple incidents of that is a very scary indicator of aggression, to the point that the legislature has added charges that just deal with strangulation as well. So that is very concerning to the state. We do feel that prison is consistent in this case, that the defendant is not amenable to community control. He's been on community control since 2020 on the 2 cases before the court. 2020 on the 2019 case, and since 2021 on the 2020 case, and has continued to violate. This is his 3rd violation on those cases, with multiple violations within these cases themselves. So we would ask this court on 19 CR 427, where he broke the window and assaulted both Ms. Cicconetti and a friend of hers, that the prison term in that case be reinstated. He is on judicial release, and he would have that. We would request to reinstate the original prison term. He would get credit for 190 days of jail credit. The prison credit that he has would be calculated by Department of Rehabilitation and Corrections, so he would get credit for that as well. However, this court would only calculate the jail credits. In 20 CR 1323, where the incident where the defendant grabbed Sophia by her arms, leaving bruising, black and blue marks on her arms, and pushing her against the wall where she hit her head. She testified to this court that she had to go to the hospital afterwards because she had such severe headaches. It's my understanding she had a concussion and that she had to take multiple days off from work. In that case, it's a felony 3 domestic violence because there were multiple priors. We do feel that consecutive prison time would be appropriate in that case. He would have 125 days credit in that case. In the 2023 case, we would ask for consecutive prison. He was found guilty of F4 menacing by stalking, F3 attempted burglary, F3 violating protection order, and 2 misdemeanors violating protection order. So they're all obviously serious offenses. None of them would merge. We do feel prison is appropriate based on the circumstances and the defendant's record. We feel that consecutive sentences would be appropriate to protect the public and punish the defendant. They would not be disproportionate to the seriousness of the offenses. It was committed while the defendant was on probation, and one of them being judicial release probation, as well as the defendant's criminal history shows. The consecutive sentences are needed to protect the public. I believe I stated, but he would have credit for 134 days in that case. And that would be the state's recommendation at this time.
is the,
I apologize, Your Honor. There's mandatory post-release control in the 2023 case. Based on the attempted burglary F3, it would be mandatory 1 to 3 years.
1 to 3, or, well, what about the F2 in the 19 case?
In the 19 case, it is mandatory as well.
18 to 3 years, right? 18 months to 3 years.
No, Your Honor. It's a little confusing, to be honest with you. When he was sentenced, he was told he had a mandatory 3 years of PRC, but at this time it would be mandatory 2 to 5 years for the F.
Effective.
Oh, you know what? I apologize, Your Honor. You are correct. It's 18 months to 3 years. I looked at the wrong one. So he would get the benefit of the new law.
All right, I've reviewed the updated pre-sentence report and previous report by Dr. Rinsberg. I've reviewed Ms. Cicchinetti's victim impact statement. I went back during the trial. I took about 6 pages of typewritten notes. I went back and reviewed my notes from the trial. I listened to counsel, listened to Mr. Berry. I've considered all provisions in 29-29-11, 29-29-12, and 29-29-13, as well as 29-29-14. Abundantly clear at this point that you're, on the 19 and 20 case, you're no longer amenable to community control, and that goes for the 23 case. It seems like, to me, that for as long as you two have been involved with each other, almost as long as you two have been involved with each other, I've been involved with you guys. Because this started, the 17 case, I believe, was from a 16 incident, and there was a 15 incident. Maybe it even goes back farther than that. Okay, so as long as I've been sitting here, I've been involved with you two. Okay? Now, on the 17 case and on the 19 case, I gave you 3 years in prison on that F2, and I think between the jail and the prison, you served about a year before I let you out, put you on probation on the 17 and the 19 case. I did that. I gave you 3 years. I forget what I gave you on the 17 case, okay? But I gave you those sentences for a specific reason, and I let you out on 5 years of community control for a specific reason. Then you picked up the 20 case. As you well know, I couldn't have shouted enough times throughout all these cases to stay away from and have no contact with Sophia, right?
Yeah.
When you were here on the 20 case, I kept you. I didn't send you back to prison on the 19, and I kept you, and I put you on probation on the 20 for very specific reasons, okay? And then after that, during the course of your probation, I would have some regular contact with Kim to find out what was going on with you. And you were brought in here a couple times on a review to find out what was going on with you, okay? And as you've acknowledged, you lied to me about that, okay? Well, worse than that, you lied to yourself about that and pretended things were going fine when they weren't going fine, when the behavior never really changed. Clearly, you have mental health problems that have gone uncontained, uncontrolled, okay? Despite the fact that you've been pointed toward resources that would help you contain and or control your mental health problems. Coupled with your use of marijuana, your tendency to exhibit anger is just a brutal combination that you've had ample opportunity to get under control, but you just haven't done it. And you haven't done it because you did not make the concerted effort to do it. And that's where it begins and ends. And I say that realizing full well that it's not an easy task, okay? But it's still a task that you have to undertake because you've been coming here for 8.5 years almost on a regular basis. And clearly, what I have attempted to do, what Ms. Randallson has attempted to do, has been a miserable failure. But as you said, that comes back on you, and you're responsible. Not only in the 23 case, but going back in time to 2015, it's been it's been a pattern that has not been broken. The same things are happening in April of 23 has happened in 2015. And there's nothing that anybody can do to break that pattern except you. Now, seems to me that there's two reasons that you should break the pattern. Okay, one reason is for yourself, because you're how old now?
31.
31. So there was just a guy in here yesterday on a case who's 74. Okay, so unless you want to keep for the next 43 years coming in and out, you better figure out what the hell you're doing and how you're going to change things. So first reason you got to change is for you. The second reason you got to change is for your daughter, okay? Because regardless of what I do, at some point you're going to get out, and if you can figure out how to put yourself in a position where you're not doing this crap over and over again, you can have a relationship with your daughter. But once again, that's up to you. So after consideration of everything I just talked about with regard to the applicable statutes and the situation at hand, on the 19 case, I'm going to reimpose that sentence of 3 years in prison. On the burglary count, 180 days on the misdemeanor offense, with credit for 190 days. On the...
Your Honor.
What?
It would be the 3 to the 4.5. It was the Reagan-Tokes. So
well, was it a Tokes when it occurred?
Yes, the resentencing was done under Reagan-Tokes on September 6th of 2019 with the 3 to 4.5 years.
When was Tokes effective? March of 19?
Don't have the date offhand, but there was initially a sentencing done and a resentencing was done because it needed...
Do you have that? Because my docket indicates a sentence of 3 years on 9/6 of 19.
Well, it's 3... The underlying number, or the initial numbers.
Yeah, that's why I'm wondering. I thought March of 19 is when Tokes took effect, and I didn't know if these offenses were before March of 19.
The offenses were April of 19.
April of 19, okay. So on the original sentence then was 3 years at a definite minimum to 4.5 years. And whether, on that particular case, whether you serve any more beyond the 3 is within the discretion based on certain criteria of the Department of Rehabilitations and Corrections, depending on what you do with your time while you're in the prison with regard to that case. You understand that?
Yes.
All right, with credit for 190 days. On the 20 case, I'm sentence you to 36 months in prison with credit for 125 days. On the 23 case, on count 1, I'm going to sentence you to 18 months in prison. Count 2, 30 months in prison. Count 3, 30 months in prison. And count 4, 180 days in jail. Credit for 134 days.
There's also count 5.
Oh, count 5 also 180 days in jail. All the sentences in the 23 case are concurrent to one another. The 19 case and the 23 case, those sentences will be consecutive to one another. The 20 case will be concurrent to 19 and 23. With regard to the 19 and the 23 cases, consecutive sentences are necessary to protect the public from future crime by you and for appropriate punishment, and these sentences are not disproportionate to the seriousness of your conduct and the danger that you pose to the public. You committed the 23 case while you were on community control on both the 19 and the 20 cases, and your history of criminal conduct indicates that consecutive sentences are necessary to protect the public from future crime by you. When you get out, you're going to be on post-release control for at least 18 months, up to 3 years under the parole authority. They will place conditions on you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for that violation, the maximum of which would be the greater of 12 months of the time you have left under your post-release control. Costs are assessed on each case. Now, before I get to his appellate rights, do you have something you want to say, Ms. Cutts?
Yes, Your Honor. One, I wanted to make sure I got this correct.
Right.
So the 2023 counts are all concurrent with each other
Correct.
and are concurrent with 2019, but 2019 and 2020 are consecutive.
No.
Okay.
2019 is consecutive to 2023.
Okay.
And the 2020 case is concurrent to both of the other cases.
And then the post-release control, I know you gave the highest one, which would be in the 2019 case. I will need to put in each of the entries what the post-release control is for each of the other cases. So I didn't know if you want to put that on the record for each of those cases or...
Well, he's only subject to one period of post-release control. And
I agree with that, but in the judgment entries, I can't put 18 months to 3 years in the other two cases. Do you want me to put down in the 2023 the 1 to 3 years, and then the up to 2 years?
You can do that, but
Okay.
just so Mr. Berry knows what the practical effect of that is. So,
Okay.
now, Mr. Berry, you have a right to appeal your conviction in the 2023 case and your sentences in the other case. You have a right to have counsel represent you in your appeal. If you can't afford counsel, then a lawyer would be appointed to represent you at no cost to you. You're entitled to a transcript of all the hearings, and if you cannot afford a copy of those transcripts, they would be given to you at no cost. You also have the right to have a timely notice of appeal filed in this case. And the question for you and your office, Ms. Springer, is if you wish to have separate counsel other than a public defender appointed to represent Mr. Berry.
Thank you, Your Honor. Mr. Berry and I have had some discussions about that, and we're not entirely sure yet at this time, and we're hopefully going to lock that down in the next day or so.
Okay.
So if we choose that there would be a conflict, could we file a motion with the court asking that?
But if your office does not intend to represent him in the appeals, then file a motion, withdraw, and indicate that you're requesting appellate counsel be appointed.
We will do that. Thank you, Your Honor.
Ms. Cutts?
Your Honor, I apologize. In the 2020 case, it would also be mandatory PRC to 1 to 3. I didn't state that.